Everybody, I'm Laura Mazerovsky, former president of the association. I ceded my title as immediate past president last night to Joe, who's here and has done just an incredible job. And we're looking forward to a year of wonderful programming. And today we have an incredible program for all of you for the Historical Society. It is really my honor on behalf of the association to introduce you to Major Bradford. Major Bradford is an assistant professor of law at the United States Air Force Academy here in Colorado Springs, where he teaches law and directs their cyber program. He received his law degree in 2011 from BYU and spent many years as a trial lawyer handling criminal cases for the military all over the world, both on the prosecution and the defense side. Very accomplished, rising to the level of Chief Circuit Trial Counsel. Major Bradford was deployed to Afghanistan and Iraq, handling detainee issues and rapid dynamic targeting. In 2022, he received his LLM in space, cyber, and telecommunications law from the University of Nebraska. And we'll be presenting today on a topic that's near and dear to all of us who are studying the interesting developments in the law of warfare, which is the law of cyber neutrality. We are honored to welcome Major Bradford and his bride of 17 years, Heidi Bradford, to our association. Please join me in giving them a warm welcome.
Well, it is really an honor to be here. I'm really excited to be here, and I hope that I can kind of live up to the hype. This is a really interesting topic. I love to talk about it, read about it, write about it. And I've been told when you start something like this, you always start with a funny story or kind of a moving story or something. However, because of the way I'm dressed and the way I was introduced, I have to start with 5 CFR 3601.105. So please, all of you know that the views presented herein are those of the speaker and do not necessarily represent the views of the Department of Defense, the U.S. Air Force, the Air Force Academy, the Department of Law, or any other component of the Department of Defense. And I'm glad you laughed at that. It makes me feel like I started with a joke. So thank you. But here we are at this beautiful Broadmoor Hotel on June 30th, 2023. A day when every single one of you, I'm going to make a prediction here, call me out if I'm wrong, every single one of you has a cell phone, or 2, or 3, in your pocket, or your purse, or somewhere nearby. Now, these, of course, aren't the old switch network phones where Ma Bell would plug in a cable here and a cable there to make a copper line connect the phones. These are what, by 10 years ago standards, are supercomputers sitting in your pockets doing amazing things. This is the age of cyber. And it affects all of our lives. Maybe it defines some of our lives. Even in third world countries, lives are at least indirectly affected by what we call cyber. Now, I know that cyber as a term is technically an adjective or a prefix, but it is often used as a conceptual noun. So as we're talking about cyber today, that can be any computer facilitated electronic communication, whether it's between people or to control some kind of technology or software, whatever. So cyber is relatively new in warfare. Now, I mean, it's been around, it's been in warfare for a decade or two, but in terms of timelines of how long warfare has been around, cyber is quite new. Now, neutrality and neutrality law is, shall we say, getting closer to its senior citizen discount in the world of law, especially law of war. So with that in mind, I'm showing you now a picture. I hope this isn't too disturbing of a picture, but this is an old wineskin. And forgive me for starting with the scripture from the King James Version of the Bible, but here we are. Neither do men, just trust me, this is actually the best place to start this conversation. Neither do men put new wine into old bottles, else the bottles break, and the wine runneth out, and the bottles perish. And I might add, you probably shouldn't try to give a modern lecture in ancient language lest the audience gets lost and throws rotten tomatoes at you. There's a lot of food there. So please just bear with me for a moment here. What does this have to do with cyber neutrality? Well, cyber activity is the new wine and neutrality law is the old bottle. So let me explain. Once again, here we are in 2023. It's been more than 3 decades since the first public internet and the advent of the World Wide Web. I still remember my first time on the internet in middle school with this fancy computer lab that we had. And I visited the M&M's website, no federal endorsement intended. It was the cool website back then. But that's been a while. And we are about an average lifetime now from the first programmable computer in 1941. And even that came more than 30 years after the Hague Conventions on Neutrality were enacted in 1910. So to sum up, neutrality in international law derives its substance from treaties enacted in 1910, 31 years before the first programmable computer and 81 years before public internet and the first web page. And yet cyber as a concept plays an increasingly indispensable role in warfare and great power competition. So scholars have now been grappling with that cross-section between cyber and warfare for over a decade. But although there are strongly worded scholarly opinions on lots of topics in that category, the fact is the international law relating to cyber activities and warfare is neither developed nor settled. So we try to plug new things into old legal frameworks, and sometimes the frameworks are made for that and it works. But neutrality law is like the old bottle and cyber activity is the new wine. So we're going to dig into the history of neutrality law a bit, but first it's important to understand what neutrality law really is and even more importantly, what it's not. So people will often ask me things like, well, hey, if there's this thing called neutrality law, doesn't it violate neutrality law if we are getting involved with Russia and Ukraine and lending support and things like that? But the thing I need everyone to understand is that neutrality law isn't so much a responsibility as it is a conditional right. So it doesn't mean the US can't get involved. What it does mean is that if a neutral state complies with the laws of neutrality, then they are entitled to certain protections. Then the belligerents in a contest by law should be leaving them out of their belligerent activities. And since I'm using the word belligerent, let me explain that too. Belligerent doesn't necessarily mean that your country has done anything wrong. It's just a term of art in warfare law. That means one of the countries engaged in the fighting. So good guy, bad guy, doesn't matter. We just call them belligerents. It's not a slight, doesn't mean they're doing anything wrong. So if neutral countries comply with the laws of neutrality, then they should be protected from being sucked into a war. And that's actually a pretty important development because before international law, there was no, international law. Even in practice, there was no neutrality. In antiquity, when fighting broke out between neighboring countries or kingdoms or fiefdoms or whatever, the neighbors kind of had to get sucked into it. They had to decide who they were for and who they were against, who was their enemies, who was their allies. Now, that didn't necessarily mean they had to engage in the fighting, but they did have to render needed assistance, allow passage through their country, and deny those same things to the other side. We can all think of where this might lead. If I'll choose my wife, Heidi, I attack you, and now we're fighting, but your neighbors like you better, and so they're helping you out, and they're helping you to thwart my attacks and helping you to attack me back better. I don't like that very much, so I might decide to attack your neighbors to take away that capability, which over time gets more and more countries involved in a war, and the war just spreads and spreads and spreads. So countries did try to be impartial during all of this early historic time, but the belligerents never recognized that impartiality. So this is the way it was all the way through the fall of Rome. And as we get into the Middle Ages, this essentially was the same, but toward the latter end of the Middle Ages, we started to see a little bit of change. Just a little, in that the neutral nations weren't exactly forced to pick a side, but there were still no rights or responsibilities connected with neutrality. So during this time, states began to try, I guess successfully, states did begin to furnish some money or some troops or other assistance while maintaining that they were not a part of the war. And other states, of course, still didn't like neighbors getting involved in ways that were not advantageous to them. But they started doing a new thing. They started to preempt that practice by engaging in treaties with each other, not like mutual defense treaties, but treaties that said, hey, if I get in a fight, you agree not to help the person I'm fighting against. All right. And so countries started to enter into these kinds of treaties, and it did a couple of things. First, it started to show the difference between actual neutrality and that not so sincere version. But it also began to develop the underpinnings of neutrality law. So this is around the end of the 16th century. And now let me introduce you to Hugo Grotius. Now, just curious, are there any Guardians of the Galaxy fans out there? A couple. You may be interested to know then that Hugo Grotius is also known as Hugo de Groot. But I've looked into it, and while the jury is still out, I'm pretty sure it's not the same person, shall we say? So anyway, Hugo de Groot, or Grotius, he was a big name in law in the 16th and 17th centuries. He's been called the father of international law, probably because of two books that he wrote that were very influential, one of which is called De Jure Belli Ac Pacis. And I know nobody will criticize my Latin because nobody really knows how Latin is pronounced. So, but it means on the law of war and peace. And so there he explains two laws or two rules that had developed regarding neutrality during that time. And here they are, kind of a shortened version. So first, neutrals shall do nothing which may strengthen a belligerent whose cause is unjust, or hinder the movements of a belligerent whose cause is just. You can see how that could be open to interpretation, right? And then second, in a war in which it is doubtful whose cause is just, neutrals shall treat both belligerents alike in permitting the passage of troops, in supplying provisions for the troops, and in not rendering assistance to persons besieged. You may notice this puts no responsibility on the belligerent parties to respect the territory of neutral states. And according to Oppenheim, they didn't. So let's fast forward a bit more and let me introduce you now. I practiced this name so many times, and I'm going to say it perfectly, to Mikhail Nikolaevich Muravyov. Now thank you. I know you did some Russian. Did that sound great? Thank you. I'm just going to call him Count Muravyov. Thank you. So this is him, or at least an image of him. A bit of a sad story. We'll get there. So Count Muravyov, he was the Russian Minister of Foreign Affairs at the very, very end of the 19th century. And in August 1898, he passed a note to his international colleagues to propose what would later be called a peace conference. In that note, he said that the maintaining peace generally and arms reduction was the ideal toward which the endeavors of all governments should be directed. And he did live to see such a conference take place the next year, but it failed to produce any kind of actual arms reduction. They did come up with some agreements of things that maybe should be, but nothing binding. A step in the right direction, but Count Muravyov tragically would die before being able to see any real tangible progress, because the next year, in the year 1900, he died very suddenly with a wound in his left temple, And there were rumors of suicide. You see, he had been in a situation where he was taking some blame for some of Russia's trouble with China. The official government version was that he had slipped and fallen in the middle of the night and hit his head on the corner of a desk. Either way, tragic. He never saw this kind of dream become a reality. And it took a little while. It had been expected that a second peace conference would take place the very next year. But the years slipped by, writes James Brown Scott, and then Russia finds itself at war with Japan over the Korean Peninsula. And I won't go into too much detail, but Russia thought they had a pretty decent chance during this war, and it started looking like actually they didn't. But when Japan offered some armistice ideas, Russia didn't like it and kind of doubled down. And in the end, Russia was soundly beaten and Japan began to rise as a world power. But after that, because we're sticking with neutrality law here, other Russian officials secured the support of President Roosevelt of the United States to invite 44 governments to another conference at The Hague. This time, first off, 3 of the original Hague conventions were revised and 10 new conventions were adopted, including Convention 5 and Convention 13 regarding rights and duties of neutral powers in times of war. So these conventions were enacted in 1910, and this is the genesis, the beginning of modern neutrality law. Of course, in the sad twist of fate, only 4 years later saw the beginning of the Great War, as Archduke Franz Ferdinand of Austria was assassinated in Sarajevo, and Austria wanted some revenge and kind of got Germany to go along with it. And then through a series of treaties throughout Europe and various acts, country after country after country got pulled into the war. So very shortly after these were signed, that's what happened. So after World War I, the League of Nations was created to try to prevent anything like this from ever happening again. And of course, that failed to prevent World War II a few years later, which brings us now to 1945 and the United Nations Charter, which is kind of another attempt, maybe a stronger attempt, to prevent these kinds of world wars from happening. Now, nearly every sovereign nation in the world would become a member of the United Nations and ratify the UN Charter. It requires all members to settle their international disputes by peaceful means and to refrain in their international relations from the threat or use of force. Now, essentially, the UN Charter has been seen as an effort to outlaw war. The UN Security Council can identify threats to peace and can call upon members of the United Nations to take measures to restore international peace and security. So if everything worked as it should, there shouldn't be any more war. There was some thought in scholarship that the law of neutrality may have become obsolete, because without war, there will be no belligerents. And Hague 5 and Hague 13 don't really say anything if there are no belligerents. I've lost this name, I'm sorry. Jimmy Guzman, a lieutenant colonel when he wrote this, explained, if the UN worked seamlessly and collective security worked in all instances, the law of neutrality would be obsolete, as there would never be a need for a neutral state. Because if you think about it, if nations are called upon to go and restore the peace, that kind of makes them so they can't be neutral at that point. But guess what, everyone? It's not exactly how things went down. Last year, as Russia acted as, I'm going to say, a clear aggressor in the Ukraine conflict, there was nothing the United Nations could do about it, because the Security Council has 5 seats that are permanent seats that have veto power, and Russia holds one of those seats. So anything the United Nations Security Council would try to do, be it a resolution or any call to action, Russia could veto. So the good news is neutrality law is alive and well. So that's our historical discussion, and now it's time to get back to trying to put our new wine into an old bottle. So here's a question I'm posing. Is there such a thing as cyber neutrality? What does it mean? If warfare is occurring only in cyberspace, then is it really warfare? Does it implicate the laws of war? Now, neutrality rules do apply to cyber activities and infrastructure, but some scholarship, my position is overstates the extent to which it does and the extent to which the law is clear and settled. So to determine what rules, if any, apply and in what context, we're going to need to look at both treaties and customary international law. So, of course, in a room full of lawyers, I don't really need to explain treaties. It's kind of like a contract between countries. Once they're ratified, you're bound by the terms that you've accepted. And we'll come back to the limits of that in a minute. And then customary international law, of course, is when we have a generalized and consistent state practice, as well as what we call opinio juris. So countries are all doing this thing out of a sense of legal obligation. They feel they owe it to the world in a legal way. So if we have those two things, we have customary international law that can be binding on countries, even outside of treaties. So back to the question of, is there cyber neutrality? Talking about just cyber activity, countries attacking each other and all these kinds of things. First off, do we have any treaties? Well, the only real substantial treaty on cyber at all is the Budapest Convention, which first failed to gain adherence of the most powerful countries in the world. But second, as far as international law goes, it really doesn't talk about anything besides criminal law and extradition. There's no discussion of cyber law of war. There's no discussion of neutrality. And it's really the only major cyber treaty out there. So then we look at customary international law. And again, for now, just the context of cyber only war, what do we have? As far as cyber activities and attacks can be attributed to countries, for decades, there have just been attacks going around all over the place. So cyber conflict, even between major world powers, has been going on indefinitely for years. And due to the nature of these cyber activities and the problems with attribution, unless a country raises their hand and says, I attacked you, which almost never happens, it's really hard to figure out who thinks what. Countries hesitate to say what they think about things or when they've been involved in things, et cetera. So we don't have a lot to go on with customary international law. It could be argued that there really is no cyber-only neutrality. So really the question is not just cyber-only conflicts, but how do cyber use and infrastructure impact neutrality in the more traditional sense, in kinetic wars? So let's look first, actually, before we go to The Hague, I do want to point out a couple of things about international law that, even if they do seem obvious, they become really important in this discussion because they seem to be missed. First off is that the law pertaining to one domain does not necessarily transfer to another. And by domains, I mean, in a war context, we have wars on the sea, we have wars on land, we may have wars in the air, or at least portions of war. So the land would be a domain, the sea would be a domain, the air would be a domain, space would be a domain, and you might even consider cyber a domain. But if we go back to these Hague Conventions, we see that they're even divided by domains. Hague 13 doesn't necessarily apply to situations where Hague 5 is going to apply. So law pertaining to one domain doesn't necessarily transfer to another. Second, when you try to extrapolate by analogy, hey, this is very similar to that, it's a great academic exercise, but it doesn't bind signatories. You have the United Nations Convention on the Law of the Sea. Very similar to some things that happen in space. But the law of the sea doesn't bind countries by what they do in space. So we have separate space treaties for that kind of a thing. And then third, regardless of the justification, no amount of creative treaty interpretation can impose upon a state an obligation to which it didn't agree. You see that in scholarship all the time when we're talking about law of war and cyber. So it's something to watch out for. So with that in mind, now let's jump back to The Hague. So of course we have the war on land and naval war. There is no convention on cyber war. And there's probably not likely to be either. Major treaties like this I'm not going to say they're exactly a thing of the past, but maybe there would have to be another world war before all the countries of the world can come together and agree to bind themselves in the ways that they used to. It's not happening anymore. I don't see in the reasonable future any kind of a major treaty on cyber warfare. So scholars have opined that, I'm going to give you air quotes here, cyber attacks or cyber weapons passing through internet nodes in a neutral state's territory would violate neutrality principles. And this is generally based on Article 2 of Hague 5. Now, I'm not going to read Hague 5 in its entirety, but I will tell you that there's no general requirement to do the types of things that tend to maintain neutrality, if that makes sense. It's limited to just the things that are enumerated. Your only responsibilities as a signatory are those things that are enumerated, because there's no general requirement anywhere in Hague 5. So Article 2 says belligerents are forbidden to move troops or convoys of either munitions or war supplies across the territory of a neutral power. Now, Article 5 puts a burden of enforcement on the neutral states themselves. Now, this is not a you must not officially facilitate kind of a duty. This is a must not allow. So even if people or corporations within that neutral territory are facilitating things that would violate Article 2, then that neutral territory may be held in violation and not have these neutral protections and may be targetable by the belligerents. So if a cyber attack passing through neutral territory violates neutrality, it could make things really difficult for any country that has the internet. You see, the routing systems that make the internet work, so we're talking about Border Gateway Protocol, they use autonomous systems, or AS, to autonomously choose routes for packets of data to travel until they reach their destination. These routes can go through several countries, even if you're sending the data next door. And one communication, one message, if you will, is often broken up into multiple packets that can even take different routes. When a route is blocked or backlogged or destroyed, the AS will simply send the rest of the packets some other way. So what we have is this impossibly large number of possible routes for any given communication, and the possibility that a belligerent could accuse any number of states whose internet infrastructure has moved a packet. So, I mean, fortunately, this doom and gloom scenario hasn't really played out in real life because, I mean, at least not yet. Cyber attacks and various cyber activity, as we've talked about earlier, are going around the world all the time. And so far, no states have been blaming territories just because, oh, you have a neutral cyber infrastructure and a packet went through your country and attacked us. And so, you know, we're going to attack you or something like that. It hasn't happened, but could it? Could countries blame other countries, neutral countries, for packets going through their territory? So there's a 2008 paper that says, contrary to the views of some legal scholars, a belligerent violates neutrality law when it launches a cyber attack that crosses the internet nodes of a neutral state. It reasons that a cyber attack does not qualify as mere communications signal allowed by Article 8, but moves a weapon across a neutral state. I disagree. This view takes unfair advantage of the ambiguity of the term cyber weapon. So the paper argues that cyber weapons fit into the United States Air Force definition of a weapon, which is devices designed to kill, injure, or disable people, or to damage or destroy property. So the paper agrees that Hague 5 allows intelligence, orders, and other dispatches to be transmitted through Article 8, but says that because cyber weapons qualify as weapons, that they're governed instead by Article 2. Now, here's the scary thing to me. This view is shared by a majority of those who were surveyed for the creation of the Talon Manual, which is a manual that strives to identify the current state of the laws of war as they pertain to cyber or cyber activity. But there are two problems with this approach. So first, There is no legal definition of cyber weapon. It's a made-up term in international law. Even the term cyber attack, which we hear all the time, is meaningless in international law. It's a phrase used by the media to describe cyber incidents and, quite frankly, I think to sell headlines. But it doesn't mean that the thing qualifies as an actual attack or as an actual weapon under international law. So even using the previous definitions of weapons, which was devices designed to kill, injure, or disable people or to damage or destroy property, most malicious cyber activity, if not all that we've ever seen, would not qualify. Now you can imagine something happening that might, but especially if damage or destroy is taken to mean physical damage or destruction. Now this paper further says that Hague 5 forbids movement of weapons, even those the size of an electron, across the territory of a neutral state. But not even electrons traverse communications lines from the sender to the receiver. It's simply information in the form of electromagnetic pulses. Electrons move back and forth. They don't go from one computer to the next. Which reminds us that we're actually dealing with communications and not logistics. So the first problem with that approach is that cyber weapon is not a real term in international law. But second, and probably more importantly, the problem with that approach is that assuming that a cyber act undeniably qualifies as an attack or as a weapon, as a weapon under international law, that still doesn't necessarily mean that it's prohibited by Article 2. Because Article 2 doesn't prohibit all weapons necessarily. It prohibits movement of troops or convoys of munitions or supplies across the territory of a neutral power. So once again, I want to point out states are only bound by treaty obligations that they affirmatively accept. And they do not have to, even though they may, accept an expanding definition or interpretation of the original treaty. So what about customary international law? Now, maybe I shouldn't do this, but I challenge anyone to find customary and consistent state practice of states condemning cyber actions as violations of international law. It's just not there, especially for neutrality law. Now, that doesn't prove that states view all cyber activities as legal within the international law framework. There are several reasons why a state may choose not to speak out. They don't want to give away their capabilities, or there's some embarrassment factor, whatever. However, there are plenty of instances of malicious cyber acts that have taken place, and those that are attributable to states could be seen as state practice, which may indicate that the state views such acts as within the bounds of international law. Now, again, states don't always necessarily act consistent with their own opinio juris. So what this all boils down to is that we really have a lack of analytically useful state practice and state positions, leaving scholars in the position of having to opine what the state practice will be or should be. That's just a really long way of saying we don't really know what the customary international law is. Personally, I think a really valuable predictor of future state practice can be found in states' official publications, sometimes, particularly those that are designed to guide the state's own officers, and specifically when it comes to neutrality law, military manuals. So the Department of Defense Law of War Manual, it has a 77-page discussion on neutrality. Exactly 1 page is dedicated to cyber and neutrality. So it acknowledges and discusses that interaction, but it states, merely relaying information through neutral communications infrastructure, provided that the facilities are made available impartially, generally would not constitute a violation of the law of neutrality. Thus, for example, it would not be prohibited for a belligerent state to route information through cyber infrastructure in a neutral state that is open for the service of public messages, and that neutral state would have no obligation to forbid such traffic. And now emphasize this part. This rule would appear to be applicable even if the information that is being routed through neutral communications infrastructure may be characterized as a cyber weapon or otherwise could cause destructive effects in a belligerent state. But not destructive effects in a neutral state or states. So now, admittedly, there's also room for states to use military manuals for deception and manipulation. So there's room to argue that this doesn't necessarily indicate, for example, the US perspective on what the international law is. But by and large, where the manuals are first provided to guide the state's officers and second made available for the world to see, these facts do strongly indicate that the manuals contain the state's actual position as to their sense of legal obligation. So, kind of concluding here, without state actions to clearly establish generalized and consistent state practice, scholars simply can't tell us what customary international law is, but rather what scholars believe the law will be or should be. Now, sometimes authors state such opinions as if they represent actual current international law, but practitioners need to understand that they don't necessarily represent the current state of the law and they are not binding on states. So I was asked to leave some time for questions and comments and vulgar insults. So I'll wrap up here and turn it back to you for any further discussion. Yes?
How there's not a one-to-one happening between, for example, let's say person with property in the Andrews C versus the cyber world. And what I was curious to know about is a lot of you mentioned cyber attacks, fine, not fine. So a lot of the cyber attacks that we see a lot of times are basically denial of service. So it's making the resource unavailable as opposed to destroying it or somehow getting it. And where does that fall? Because that doesn't seem to be something that I think has really been contemplated when it comes to when we look at war on land, the idea of making the resource unavailable, but we're not actually funding it, we're just saying we can't get it.
So let me try to summarize the question for our online audience. Your question is regarding how things are defined in international law, and specifically with cyber attacks. A common version, or probably the most common version, is the denial of service attacks, which makes something unavailable for a period of time. It doesn't necessarily destroy or even damage it. So how does that fit in? Is that a good summary? So this kind of draws my mind to some other areas of law of war, jus in bello, jus ad bellum, where we start talking about what is an armed attack, what is destruction, what can you target? Does it have to actually be destroyed for it to count as something you have to consider the laws of war for? And there is some question, especially in the cyber realm, as to how we should look at that, whether we look at it as an effects-based analysis, like what are the end results? Did this denial of service attack shut down some critical cyber capability such that people predictably started rioting or lost their drinking water and people started dying? Do we look at that from an effects-based lens, or do we look at it more as what was the means that was used to do this? There are actually, I think, 7 different criteria that I don't have memorized. Not criteria, 7 different ways to look at attacks and cyber. And quite frankly, there's no consensus necessarily. Nobody really knows, because we haven't had cyber attacks that have killed anybody or, for the most part, destroyed things. The closest is probably the Stuxnet virus that kind of damaged and shut down some centrifuges. And even that, nobody was saying, oh, this is a violation of international law, or this classifies as an armed attack, necessarily, even if attribution could be made. So the only answer to your question, I think, is just a big question mark. I know that I disagree with some scholars, and they disagree with me, and they disagree with each other. And a lot of us have really strong opinions, but there is no treaty on point. And our prior discussion about customary international law still applies, that there's just not enough there to analyze and say what the law is. So I really could summarize all of today's discussion and just about everything cyber and law of war with a big, like, people might say they know, but nobody knows. I don't know if that was a satisfying answer. Is that close enough? Is there a follow-up?
Actually, I didn't answer the door, I just for the toilet, but I certainly put clothing on, right? So where does that fall? I mean, like things you're not allowed to do, or things that you would consider to be an aggressive attack, or whatever the language is that, would characterize it as being something that would be falling under an act of force.
I like that. So the follow-up for all of you online is, I think, a great example of trying to prevent somebody from getting into the bathroom. You sit there in the bathroom, in front of the bathroom, and they can't get in. You haven't destroyed anything, but you've prevented them from being able to use the bathroom. So where does it, can you re-ask the last part of your question? So where does that fall within the realm of what's allowable or not allowable? So technically and strictly speaking and reading the law, I would argue that just about everything that the world is capable of right now in cyber is technically allowable. It's not a very satisfying answer though, because part of international law isn't just if we were to codify this, did you break the law or not? Part of international law is predicting what the results are going to be, what the responses are going to be. So on the technical side, I say just about anything we can do in cyber doesn't break any law. Again, people disagree with me. But the functional real world application piece of it is if you're sitting in front of that bathroom and blocking it, yeah, you haven't broken a criminal law. Maybe there's a tort lawyer in here who would take that up. I don't know. But the real question is, what's the response going to be? Is somebody going to come after you with a baseball bat because you did that, even if it's not a violation of the law? And so that ends up being where the rubber really meets the road, is kind of that predictive aspect, which really that's kind of what international law is for, is to be able to have some idea of how the world works and how people will respond. So technically, probably nothing, maybe, at least that we're capable of now, is going to violate the law. But from a predictive kind of a perspective, we just need to look at how is this going to be viewed in the international community? How is someone going to respond? And how is the rest of the world going to see us and them in this conflict? Yes, sir.
War on the sea does not apply to war in cyber, but is there any kind of learn from how blockades are?
So the question is, we're following up on that, thinking about a blockade in naval warfare. Is there anything we can learn from comparing that to something like a denial of service attack, right? And yes, Hague 13 talks about things like blockades and things that happen on the sea. You can draw analogies for scholarly purposes, but again, that's not going to bind anybody. So someone might make the argument, hey, blockades in naval warfare are only allowed in these specific circumstances, or you can only blockade the belligerents, but not, these ports, but not those ports. And so we can extrapolate that out and say, well, maybe you can only do denial of service attacks on these types of targets, or else you might be violating, Hague 13. But again, different, I just forgot the word, domain. Thank you. Different domain. And so I hate to say everything's fair game, and I don't really believe that, but from a technical, what is the actual law perspective, kind of everything's fair game. Scholar-wise comparisons are going to be really useful. And quite frankly, they're probably going to help us predict, because countries are probably going to do the same thing and say, hey, we all know from naval warfare, these kinds of things should be out of bounds. And that's kind of what you did over here. So we don't like that. And we, as an international community, are going to sua sponte kind of respond in such a way. So the predictive value of it, I think, can be really high. Yes.
Psychological operation before and after all of the things. And if not, if the PSYOP is covered by the Hague Convention, just your prediction as to where that's going to go with this information things that may inspire panic in the population, or
Okay.
Any
So the question being, do psychological operations predate the Hague Conventions? And I guess what does that mean in modern times when we have all of this misinformation and the possibility of kind of creating a panic and those sorts of things. I don't actually know, but I'm guessing that information operations are probably as old as warfare. They just happened in different ways. I'm trying to think through reading these two conventions, and I don't remember seeing, I definitely didn't focus on that. I'm not even sure it's there as far as neutrality goes.
There's so much in the news today about misinformation, habit that can be, on a nation's instruments of power. Go back to your day.
So we're talking about misinformation and disinformation, the havoc that can wreak on a nation's power. And that's a big thing today. I mean, that's a huge deal today. And we believe that Russia is heavily involved in doing those kinds of things. So let me back up to international law in general and kind of back out of neutrality law. Everybody here knows that espionage is illegal, right? Guess what? It's not illegal in international law. It's only illegal by domestic laws. We will put somebody to death for committing espionage, and probably every country in the world will. But it doesn't violate international law, because no one has ever signed a treaty saying we're going to stop doing espionage. And we've been doing espionage on each other forever. So the customary and consistent state practice is we're going to do espionage. And we all do it to each other, and we all know we do it to each other, and that doesn't violate international law. Now, if we catch you, we're going to apply domestic law. And so that's kind of where we are, I think, with these information operations, is they probably don't violate international law. Now, there are debates out there also about sovereignty and cyber. Does doing cyber activities within a country violate their sovereignty? But if you think about it, I don't want to pick on Russia. Falconia, the nation of Falconia, wants to come and do espionage. They come into our land with a passport. We let them come in. We didn't know they were going to commit espionage. And then they commit espionage. That doesn't violate international law. That doesn't violate our sovereignty. We let them come into our country, right? So it is really interesting that these things like espionage are one of the most gross and egregious things that we have, yet it doesn't violate international law. So, yes.
And it seems like the law of neutrality is, if I commit cyber warfare against you, my act of commission of that is a breach of international law. But if I go through another neutral country to do it, is that where the violation comes up with that other country's obligation to stop me from doing it? Is where they're in trouble because they should have stopped.
Okay, so
It seems like I've done something wrong. We were kind of ignoring the big picture, and I just did cyber warfare against you.
yeah.
So what we're talking about is, well, that you went through another country, and then another country allows you to do it. Now we're focused on kind of that periphery.
So again, for the online community here, the question is, if we commit something that is cyber warfare, and let's just assume that it's kind of violative of all these principles we're talking about, if we just commit that directly, are we not violating international law? Whereas if we go through another country, we then are. And the answer is only if neutrality law is the only international law. Because we also have those laws we didn't talk about. The jus in bello is what we can do during times of war. And if it doesn't, if you're not supposed to make that attack, it's still going to violate international law. Now, if you're in a declared war where you're allowed to make attacks, as long as it is a valid military target, it doesn't. But then you go through another country, and just for ease of discussion, let's just pull cyber out of it and say, instead of rolling our tanks directly into their country, we go through a neutral country. Without their permission, we have violated neutrality law. Or if they kind of facilitate it, they may have violated neutrality law. But you just have to remember there's more law out there than just neutrality law. So just because it didn't violate neutrality law doesn't mean it didn't violate some other law. There's a whole body of law on what we can do in war and what we can do in starting a war. Is that helpful? Did I see another hand? Yes, sir. Yes.
treat some of these cracks as even profile.
So that's a great question. When we talk about the effects-based analysis, can some of these things be violations of humanitarian law? Like if you do a cyber attack that shuts down a hospital or something along those lines? I'm going to say yes, not necessarily neutrality law, but when law of war and international humanitarian law are kind of a Venn diagram that overlaps a lot. And sometimes lawyers will use those terms interchangeably, though there is a slight distinction. When we're talking about what is humane and things, I'm probably stepping out of my realm of expertise here, but it does tend to be more effects-based. So when we're talking about like genocide, which is the quintessential violation of human rights law, we don't really care how you do it. It's a violation, and plain and simple. So hospitals are a great example. Yeah, I guess I'll leave it at that. Unless you want a war story. This is a brag war story. I like to brag. I was sitting in a room as we were doing some dynamic targeting, and there are discussions going on as we're about to drop some bombs in some places. And sometimes operators don't like lawyers getting in their business, right? These I don't think were that type. We had a good relationship, but I overheard from across the room something along the lines of, well, let me skip all that and just say, I asked some questions, and it turns out there were power lines, and we decided to look into where those power lines went before dropping the bombs, and it turns out they powered a hospital a little ways over, and so that changes the analysis. I know we're not talking about this part of the law of war, but there are certain analyses that you have to do first off under the law of war, but then you're also going to have your rules of engagement and things like that. And that analysis changes when you expect civilian damage or casualties. And so if it's a valid military target, that doesn't mean you necessarily can't attack it just because it may kill or injure civilians or civilian infrastructure. And I think that's a misconception that's out there. For policy reasons, if we can avoid that, we will. And the law of war makes you consider it. But just because there will be civilian casualties doesn't make it an unlawful target necessarily. There are some balancing things that you have to do. In this case, there are ways to kind of change the ways that bombs are dropped and everything to make it so that it's not going to harm certain things. And we end up with a happy ending. But hospitals are one of the things that is a huge consideration in laws of war. There's this thing called perfidy as well that we as the United States, I hope, don't do. But the adversaries in the wars that we've recently been wrapping up do, where they essentially use your reliance on the laws of war to trick you. A great example is fighters riding in a Red Cross marked ambulance to get to or from some attack. You're not supposed to do that because we don't attack ambulances, and we don't want the world to start saying, well, that ambulance is just as likely to be full of fighters as injured civilians, so we might as well attack it. We don't want that. I guess I forgot where I was going with this. Perfidy is a violation of international law. And hospitals are one of the big things that we watch out for. Now, it's sad when we have, jihadists who like to hide their councils and their munitions and their people in orphanages or hospitals or schools. But there's a big difference between early stages of a war where there's a lot of explosion and dying versus where we've been more recently in the fight against ISIS or the latter years against Al-Qaeda, where we have complete control of skies and it's just kind of pieces here and there. There's not a whole lot of risk, for example, of ISIS resurging because we missed this particular opportunity to kill this particular leader. So we may forego that, whereas in earlier stages of the war, it may be so critical and we have a lot of people dying, like we have to take advantage of that. So, and I know I've gotten way off of your questions. Can I come back to your question really briefly, sir? A piece that I kind of forgot to address. We were talking about kind of what do we do if someone is committing these acts that are not necessarily violations of international law or a country. Now, there are things that we can do. Anything that doesn't violate international law, we can do to that country in response. So we can, well, take Ukraine and Russia, for example. We tried to cut off Russia using a coalition of countries from being able to make money. You know, we put sanctions on them. That doesn't violate international law. Anything that doesn't violate international law anyway, we can do. And then there are some instances where we can take certain steps to stop things from happening, things that would otherwise violate international law, but because they're doing something and it's attributable to them, we can take what action is necessary to stop that from happening. Now, when we talk about Chinese or Russian nationals doing their hacking and espionage, like, what do? We don't attack China and Russia. In fact, we can't, you know, we can't attack them for committing espionage in keeping with international law. So what do? Well, we put them on a list. We indict them. And we say, you know what? If you ever come here and if we ever get our hands on you, we're going to try you, right? And that's really scary to them. Not. It's a badge of honor, you know? They go back home, they're like, haha, the US indicted me. I was so effective in like helping my country. And it's a badge. So what is really the punishment? Well, they can't come to the US or we'll catch them. So they can't go to Disneyland in California. Maybe they can still go in Hong Kong, you know? I looked up what is the #1 like tourist destination in the US. And according to Google a few months ago, it was the Grand Canyon. So that's the punishment. If you come to our country and you commit espionage, we will indict you and you can't go to the Grand Canyon. So there you go. All right. I don't know if anyone's here who's going to wrap this up. Okay. I guess I could just talk forever, but thank you very much. This has been really fun.
Well, that concludes our lunch. I wanted to thank the Historical Society, the Federal Circuit Historical Society. I don't know if there are any members here, but they organized this lunch. And I think I learned a lot to think about. So thank you very much.